Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann.
And hello everyone, welcome to the show. I'm Shauna Sanford. Today we continue our conversation about landlord-tenant issues. There are so many people out there with some very serious problems, and our guests today are two attorneys who handle these kinds of cases day in and day out, and there's a lot of them, John.
That's right, and today we're happy to welcome back Amanda Golob and Tuggle from Southeast Louisiana Legal Services. They will be with us in just a few moments.
That's right, but before we get to our guests today, you know, we talked about the landlord-tenant relationship so much during our last show, but the question is, are both the landlord and the tenant held to the same language when it comes to the agreement?
In general, under Louisiana law, adults are allowed to enter into contracts, and you can have written contracts and oral contracts, contracts that are not written down, but just you and I agree between ourselves to do some deal. And the question is, with a lease contract for an apartment or to rent a home, the short answer is yes, you are held to that contract. And it cuts both ways. We mentioned before on the last show that typically it's the landlord, the person renting the apartment, who gets to draw up the contract, right. And typically there are many things more favorable for the landlord. But ideally, you won't sign that contract unless it has in there protections for you. So we're going to talk about that more today.
That's right. You certainly do have rights when it comes to that landlord-tenant relationship, and we're going to get into those as soon as we come back. But we have to take a quick break right now. When we return, attorneys Amanda Golob and Tuggle from Southeast Louisiana Legal Services will join us, so stay tuned. Hello everybody, welcome back to the show. Well, our guests are with Southeast Louisiana Legal Services, which handles various legal issues and provides assistance in civil cases to people who can't afford attorneys.
And they see a lot of cases involving landlord-tenant disputes. We've learned quite a lot last week about these issues, and today we're going to pick up where we left off with attorneys Tuggle and Amanda Golob. Welcome back. It's a pleasure to have you here again.
Thank you for having us back.
Well, we got into a lot during the last show, and there's still so much more to talk about. And repairs are a big issue when it comes to landlord-tenant relationships. Of course, tenants wanting certain repairs made, landlords perhaps making them or not making them. So let's talk a little bit about those issues that pop up, which I'm sure you all handle a lot of.
We do.
So let's start with you, Amanda.
The first thing that, and I can't say this enough, and I will say it till I'm blue in the face, is if you are a tenant and there are repairs that need to be made, you cannot withhold your rent until your landlord makes those repairs. Because now you are in breach of the lease by not paying your rent. A lot of tenants, especially because other states have different laws, they say, okay, landlord, my pipe's not working under the sink, I'm gonna not pay you your money until you fix this property. But under Louisiana law, you're now in breach of your lease for not paying rent. So the first thing I would say is do not take that route of withholding your rent, because it's just going to get you in trouble. In Louisiana, for tenants, if there is a problem that you want the landlord to repair, it has to be necessary and reasonable. Those are the two standards that it has to be. So necessary things, usually plumbing, electricity, air conditioning in the summer, because we all live here and know how that is.
Right.
So
heat in the winter.
Yes.
Yeah, and it might be necessary and reasonable, but you can't simply just do the repairs and deduct it from your rent. There are certain steps under the law that you have to take before you're allowed to deduct the rent, right?
Right.
Why don't you walk us through those steps?
Louisiana does have this variation on rent withholding. We have something called repair and deduct, and then a couple of years ago the legislature actually amended that provision and allowed for a tenant that properly goes through all these steps that we're going to talk about to demand an immediate reimbursement from the landlord. But so far I've never had anybody I've never had anybody do that. And so there's a number of steps. As Amanda mentioned, the repair has to be necessary. But in addition to being necessary, it has to be something that is the landlord's duty to repair. So this is where battles come. The tenant is going to say, more often than not, landlord, it's your duty. The landlord is going to say, no, tenant, you broke that. And then, you know, the
battle begins.
That's why we have courts. And so if, let's say it is a necessary repair and it is the landlord's duty to repair, then the tenant is going to need to notify the landlord, hey, I've got a problem. Notify them before it becomes a big problem, if possible.
A written notification?
We recommend you do it in writing because memories can fade, or maybe there's a different property manager or that sort of thing. So we do recommend.
If it's in writing, hopefully like by a fax, with a fax confirmation or even a certified letter, return receipt, then it's not going to be a he said, she said argument later on.
Correct. And even, these days we have a lot of folks that are sending emails, and we see the text of the whole conversation between the landlord and the tenant. And,
yeah, when the landlord responds to the email, then you know he or she got the email.
Right.
So there's your confirmation.
Right.
Correct.
Right.
But on the certified mail, we do tell folks to send certified, but we also recommend regular mail because a lot of people just won't go pick up certified mail, both landlords and tenants. So then the next step, after you've gone through all that, after you notify the landlord, you have to give them a reasonable opportunity to try to fix it. And that's one of the areas of the law that drives people crazy. What the heck does that mean? It's really going to depend on the nature of the repair. If it's an emergency item like no air in the summer, no heat, raw sewage backing up, you're probably talking about a very short window, like maybe 24 to 72 hours. But some of the case law on this, sometimes it says 2 weeks. It just really depends on what it is. So after you've given the landlord the opportunity to make the repair, if they still do not do it, then that's at the point where you as the tenant can kind of take matters into your own hands. You don't get to just deduct. You have to actually repair and deduct. And then the repair that you did to the landlord's property, you have to make sure that the cost that you paid for it is reasonable. You can't just go out in the middle of the night, cold winter, the pipes burst, and you get the most expensive person that that is available. You have to be reasonable, and because it may become a legal matter, we usually recommend that you try to get a couple of estimates so that you can show, well, here's 2 or 3 estimates.
So even
it's complicated.
Even an emergency situation like that, maybe it's not the most expensive, but maybe it's the person who was available, who you were able to get. Still, you can't just hire that person and have that repair made and then deduct. You have to get bids.
You don't have to get bids so much. You can make calls. You can have somebody email you something. You may be able to just print out, okay, I went online and this is what I found out. So, but you still do have to go through this process. And the problem with the repair and deduct remedy is, at any point along the way, if something went wrong, you may have hurt yourself in being able to avail yourself of that remedy. You may not be able to deduct that from your rent. And then there's some other limitations on, sometimes you'll find a repair, it ends up being a very serious repair. Let's say your rent is $1,000, but you think this repair may cost $500. So if that's the case, you go through all that and you deduct the difference, and then you got to let your landlord know that you really did it.
But when you say
if it's more than $1,000, unless, in general, you can't spend more than your monthly rent. So when you get in that problem, you're really talking about something that's kind of beyond what you can handle through repair and deduct.
So when you're looking at the cost is a big factor when it comes to determining whether you can actually deduct those repairs from your
Correct.
rent.
Let me ask a related question. If the landlord refuses to repair, you'd also be able to argue that the landlord is in breach, and that would allow you to break the lease and go live somewhere else too.
It could. And
I mean, if it's something that's significant. I mean, if it's a drippy faucet in the second bathroom that you don't use that often, that might not be maybe a big enough deal. I don't know, but it seems like if the landlord refuses to make a repair, you should not be forced to take money out of your pocket.
Right, and it's really going to depend on the severity. I mean, if you're talking about an electrical hazard, that's going to be a danger to you and your family. So, you don't want to put yourself at that kind of risk, but you're going to have to really document. And that's one of the key things, is that documentation.
Well, we were talking earlier, and you said there are some cases where people have made repairs, and then the landlord refuses to renew their lease.
That happens. Occasionally, you can have followed every one of those steps in the right order, and the landlord then could turn around and say, you know what, your lease is up for renewal. I don't think I want to rent to you anymore. And if your lease is expired, or if you're on a verbal month-to-month lease, the landlord has the right to do that. And so that is always kind of something you want to keep in mind if you want to take that chance.
Well, I want to mention one thing, and I mentioned it on the last episode. If you have a landlord who doesn't treat you properly and doesn't repair things the way the landlord should repair them, it's probably a good idea to go looking for another place to live anyway. It's generally landlords who you have to force to fix something. They're not going to change their stripes and start treating you better after you force them to do the right thing. And I've had clients that come talk to me, on personal injury matters. They know me, but then they ask me about this landlord thing. I'll tell them, look, let's see what we can do to try and force the landlord to do the right thing. But probably your best bet and your energy is better spent trying to find somewhere else to live. He's broken the lease. Let's get you out of this lease. But what about if you want to make improvements on your own nickel? Is that okay if you want to paint the interior of your apartment? Do you just need to get permission to do that?
You definitely want to ask for permission for something like that, because if you go and you paint a unit without the landlord having given you permission, you're asking for trouble. Another area that comes up is what if you make other sorts of improvements? If they become a material part of the structure, they basically become part of the property, you've got to leave it there. If you came in and you put in beautiful ceiling fans, if it's going to damage the property when you leave, you got to leave them there. And there's a number of other examples, and one area where this can sometimes come up is if you have a tenant that, if you're disabled, or maybe you're already disabled when you move in, but your condition worsens. There is a federal law called under the Federal Fair Housing Act that does allow a tenant, if they can afford it on their own dime, to make what's called reasonable modifications. So you may be lowering cabinets, or you may be widening doorways for wheelchair access. And it's very complicated. That's probably another show. But if you're going to make those type of modifications, you either have to leave them there, or you have to set aside enough money to remove them and be able to remove them in such a way that it's not going to damage the property.
One of the things too that I think people are probably really interested in is knowing about when the rent can be raised or increased. And I know that you mentioned earlier that if you were in the middle of a lease, that your landlord cannot evict you or terminate your lease without cause. But when it comes to that rent, can your landlord raise your rent if you're in the middle of that lease for whatever reason he or she sees fit?
If you're in the middle of a lease term, they can't, but at the end of the lease term, your landlord can raise it triple what there's no set amount as to how much they can raise it. There's no rent stabilization or rent control in Louisiana. So if you rent a place for $1,000, your lease is up, the landlord says, I now want $3,000, you have to decide, if you're going to pay that or you're going to have to move.
And by the same token, you can go find another apartment or tell the landlord if he doesn't lower the rent, you've got a comparable property that rents for $750 that you're going to have to take advantage of. So you can both negotiate with one another.
And just like there's, good, if you have a good tenant, you're as a landlord, you're going to want to keep that good tenant. And if you're a tenant and you have a good landlord, that's worth something to try to keep that relationship.
Yeah, if you have a landlord that respects that respects you and who appreciates you, that's a very valuable relationship, because there's a lot of bad landlords out there, and there's not that many really good landlords.
Well, I would say this. We actually, because folks come to us when they're in crisis or in trouble, we unfortunately mostly meet landlords that are quote unquote bad, or that may be more difficult landlords. But there's some good ones out there.
So we hear about this. We hear about the squeaky landlords, the ones that get the attention. The good landlords are below radar.
That's right.
I always say
it's a fair point.
If there's a landlord and I don't know your name, that's a good thing.
That's a good thing.
Okay.
Well, listen, we have to take a break right now. Coming up next, our guests will take your questions about landlord-tenant disputes. So stay tuned. We'll be right back.